Good morning, Chair, Commissioners. The witness this morning is Matthews Sesoko, and the witness is ready to be sworn in.
Thank you. Is Matthews Sesoko, are those your full names, or do you want to state your full names?
That is correct, Chair. My name is Matthews Sesoko.
Thank you. Do you swear that you are going to swear or affirm, or which one?
I will swear.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair.
At the start of the investigation, assume that the investigation has been authorized, either in terms of 28.1 or 28.13, and then a docket or an inquiry is opened. Shouldn't the Section 27 affidavit be the A1 statement?
In practice, Chair and Commissioners, the Section 27 referral is treated differently. When an investigation starts, when it's authorized, then the complainant is approached for an A1 statement, and a full comprehensive A1 statement which would address all the elements of the offense is then obtained. And that is what is used as the A1, not the Section 27.
Where does one find that? Is that in the manual or is it your interpretation?
It's the practice.
But where does one find that? Where is it recorded that that's the practice?
I'm not sure if we record it like that in the manual. I must be honest. I'm not sure if we do that. I think the manual states the processes that must be followed, but it does not specifically say what happens in relation to Section 27 or an A1 statement, because it's more of an investigative operational issue that investigators do.
And the reason we are asking this is because Mr. Peter Serunia, and Ms. Ramsamy, they have testified in this commission that, and I hope I'm not confusing their evidence, and the transcript will bear that out, but they said the Section 27 affidavit becomes the A1 statement, and then any further statement obtained from a witness supplements the Section 27. So the Section 27 is not an internal document. It is the genesis of the investigation. It is the affidavit that must set out what offense is being reported and what offense must be investigated, so that what the investigator looks at and what guides the investigating officer is in fact that affidavit.
Chair, I won't dispute that it may happen in other matters, that, the Section 27 may have been included as an A1, But I'm talking in generality what I know would have happened in most of the matters.
But because IDAC has not had that many Section 27s, you said so yourself, most of your matters are from the commissions, and there was that general authorization from the former ID. Don't you think this is something that should be clarified in the manuals?
Yes, certainly, Chair. I mean, this experience with the commission, it's a lot of lessons learned for us. We already having a discussion internally about IDAC reset and how we improve our operations, and including our manual, so that we are all clear in terms of processes, because this process has shown the weaknesses within the organization that really need urgent attention.
And these weaknesses are serious because they can lead to systematic failure. They can impact not just IDAC, but other law enforcement agencies, as you have seen with crime intelligence and SAPS.
That is true, Commissioner. Lessons learned.
Thank you.
Can I? Can I just check? You say in paragraph 59 that there is a practice in IDAC that if you are not involved in a matter, you don't seek to know its details, and this relates to the principle of being neutral. But surely that position in practice does not apply to the ID.
Yes, it does. It does not, Commissioner, because she's the ultimate person that takes decision on all these matters. A matter cannot be enrolled without her approving that. So every decision of this nature, it is taken by the ID.
But then by same, well, not same, you are head of investigations. It seems to me you should know what's happening in investigations.
Yes.
So that rule, if it's a rule in the workplace, should not be applying to head of investigations, because you need to be able to speak to the investigations that are happening in your organization.
That is correct, Commissioner. And in most matters, that's what had happened.
Yes.
As I said, this was an exception.
So in a properly working IDAC, a person in your position who is head of investigations is supposed to know and be involved with investigation. When I say involved, I don't mean you run and do the investigations,
yes,
but you, because you're the overseer,
yes,
of all the investigators and of investigation. So you should know this.
That is correct, Commissioner.
Okay. Therefore, it must mean I'm trying to determine whether it's this a person problem that you ended up in this position where you don't know.
I don't want to comment, my friend. I'm good. I'm fine.
So are you confident this time around that you did nothing wrong?
No, let him not comment.
Okay.
Five things. There was no objection to him being unpaid. My learned colleague on behalf of the state was part of the prosecutorial team that took the decision not to oppose bail notification. Accused number 5 was then again arrested and brought before the Joburg Magistrate Court, where he appeared on a Schedule 6 offence. There, the team leading the prosecution, including my learned colleague, chose, despite the fact that it was a Schedule 6 offence, not to oppose bail. Bishop, now we are charged again. We are arrested again. We brought before court, and after this concessions by the state in these two previous occasions, Schedule 5 and Schedule 6 offence, that we do not oppose bail. Now we are told that the bail is being opposed. So Your Worship can, with respect, understand how we are perplexed. At this stage, by the state, we previously adopted an attitude by we're not opposing bail, even on Schedule 6 offence, when we're told we are now opposing bail, and we're not told why. Your Worship, so with the greatest respect, at the very least, we submit we're entitled to be informed why bail is being imposed.
In this regard, also furthermore, in an effort to clarify this, we sent further particulars and requested the state to provide us with further particulars. My learned colleague confirmed that he'd received it, even though it was sent to him yesterday. He indicated he only received it this morning. We have not been provided with those further particulars, Your Worship, and until we have been provided with those, and I'll address Your Worship on this issue, because I think Mr. Nell is going to take or address Your Worship on a preliminary issue. But until we have been provided with that on the charge sheet as it stands, we cannot agree to the fact that it is Schedule 6. If we proceed as it is at this stage, Your Worship, we will follow the so-called scattergun approach. We will not be able to focus on what might be in dispute, because the state has not indicated, other than the fact that they claim it's in Schedule 6, why they would oppose bail in this regard. So until we have that information, Your Worship, we're going to have to address all the relevant issues, which in itself will prolong unnecessarily these proceedings. But we are ready to proceed, we are ready to continue. But without our further particulars, the right to bail, as was said in Mark's case, Your Worship, and confirmed in Green's case, will become illusionary